Appreciate you all being here today. My name is Joe Liniak. I'm part of the banking group here at the firm. I'm joined here with Sam Bolstead, who is part of the cybersecurity, privacy, and social media privacy group. And we are going to be, this is one of those topics as lawyers is bad news for clients, good news for us, particularly if you've still got to be spending college tuition on your kids, because this is not going to be going away and is going to cost people a lot of money and a lot of legal time. So that's good for us. It's the California Consumer Privacy Act. We're going to look at some of the historical issues, the statutory components. We're going to talk a little bit about the European's General Data Privacy Regulation and do some comparisons. And we're going to talk a little bit about federal preemption. And in terms of, just the issues of the day, over the weekend you may have seen that Marriott suffered 500 million losses in terms of folks who stayed at their hotels. And this morning, Google admitted that they've got 52 million people. They lost that data as well. So it's something that is timely. It's a public policy issue, and again, it's going to occupy a lot of our time. Question that starts out, because we're not in California, why do we really care? Unlike other state privacy laws, the CCPA now includes statutory damages for breaches. That's similar to the Telephone Consumer Privacy Act, where all you need to do is to have the proper type of breach of identity of a consumer, and we'll get into what that means, and you've got statutory damages, which can wreck your entire day. In the case of Marriott, it'd be about $50 billion if they were all located in California. So that's no small amount of money. And importantly, why do we also care? California takes a very, very expansive view of what it means to do business with a resident of California in order to be covered under the Act. So two components, liability as well as coverage, important components for going back and deciding to what extent you want to comply. As background information, California has always had a very, very strong concept of privacy, and in fact, unlike the federal Constitution, it's in the state's Constitution itself, which talks about life, liberty, pursuit of happiness, smoking pot, and privacy. And if you want to completely blow your mind, go to this component here at the California Attorney General's office, and there are literally dozens and dozens of privacy statutes which will make you all crazy, saying, did we really need all of these? Well, the answer is California loves privacy laws, and what's an additional one for us? Let's take care of all the other businesses outside the United States and inside the United States in order to cover them. As a short history, what happened in 2018 is that California, as you may know, has this ballot initiative, which allows you to put all sorts of crazy stuff on the ballot, and the California voters, if you do it properly, will pass it. Usually it becomes a constitutional provision, and the problem with something becoming a constitutional provision under the ballot measures is that it is really, really difficult to get rid of it. Well, a couple of privacy advocates went forward and wrote a really, really stringent privacy initiative that was going to go on the ballot, and folks like the Googles of this world and the Facebooks of this world and others and business interests said, oh my God, we got to fix this, and hurriedly began to negotiate a statutory version, which is much easier to fix. And in the last day, before they had to certify the ballot initiative, they adopted what became AB 335, which was the original version of the CCPA. And at the same time, they're negotiating a cleanup provision because they realized that 375 had a lot of flaws in it, and we'll get to that in a moment. And so the governor signed it the last day, and we are now moving forward. The CCPA creates 5 legal rights for California consumers, and we're going to go through them, and then we're going to later on talk about how the things are implemented. And I think, Sam, you start out with the the first one.
Yeah, thanks, Joe. So the right to know what information is being collected, sort of the fundamental bedrock principle for the CCPA. Some of this is a concept that's embedded already in every company's online privacy policy, but the CCPA takes it a step further. The policy itself for any company that's posted online is going to have a number of additional specific disclosures going into greater detail on what information is being collected about a consumer, both in terms of what they're collecting from, a web browser, visiting a website and collecting, how many clicks do they have, how long do they spend on a page, but going into greater detail also about what is that information being used for, who's it being shared with, and then taking it to the next level is the right to know specifically what information is being collected about you as an individual by submitting a verifiable consumer request to the business. So if I'm a California resident, I can submit a request to any company that's subject to the CCPA, and they have to provide a specific response to me about what information they're specifically collecting about me. That's not unlike the Federal Freedom of Information Act that any government entity has been subject to for decades. Now it's going to be applying to a lot of private businesses that simply have never had to deal with providing this sort of right to a consumer before.
And I think Sim's point is very well taken. For those of you that are used to FOIA requests for the federal government or public records requests under state law, this has really become a FOIA for private companies. God help us all.
So this is going into a little bit further detail on it. Again, explaining, you see the top level bullet point there, the categories of personal information it has collected, it being the business. And then you get all the way down to the bottom bullet point, and you're providing not only a general description, high level of the types of information that you're being collected, but for a verifiable consumer request, you're providing a consumer with the specific information that you have on that person. Now there's a whole subset of issues here about how do you verify that a consumer that's submitting a request is the person who they say they are, and that the information that they're requesting is really about themselves. So I can't pretend to impersonate Joe and ask Facebook to provide me all of the data that Facebook has on Joe. A business is going to have to set up a process to verify that a consumer submitting a request is who they say they are, and make sure they don't give information out on someone else.
And I think the experience right now under the GDPR is that this is a very, very difficult issue to be able to handle. You get a request, you really don't have an account. How do you know the person is the person, and how do you go about verifying it? I can't tell you what the answer is, but it's laying out there, and these are the things we're going to be getting into the weeds on over the next year or so. This is an important point in that, like the GDPR, you're going to be able to call up your friendly neighborhood grocery store and say, you've got information on me, stop selling it, and by the way, delete it. It's the so-called right to be forgotten. And one of the things that I know you're thinking about right now is, what about if you've got information about the fact that somebody committed a felony? Well, believe it or not, there's not an exception for retaining information about a felony that you've got on as to an individual. How do we go fix that? Well, we're probably going to need to go back and get some and get this amended. But can you imagine what would happen if you've got information, say, in the HR department about somebody who has committed a foul act, and they write to you and say, hey, delete this? Right now, technically, the way this works, you would have to delete that information because you've got the right to be forgotten.
There are a couple caveats or exceptions to the right to be forgotten that we'll get into, and ostensibly some of them could be used to try and push back on scenarios like the one that Joe is talking about, but there's some hope that we might get some guidance from the California Attorney General on really the outer boundaries of some of these rights.
There's also, and I think this is a good idea, a non-discrimination provision in here, in that you cannot discriminate against somebody who exercises their rights under these various privacy rights that have been created. And one of the ways you can't do is you can't discriminate against someone exercising rights by pricing differentials that are imposed by you in terms of providing the goods or services which you're going to sell. But there is a problem in terms of the way that they amended it as to this final provision, and why don't you explain that?
Yeah, so the most common way that I expect to see this requirement playing out is that a company will still be able to provide, well, hopefully, they might be able to provide a different level of service to a consumer depending on whether the consumer agrees to the scope of data that the business can collect on them, share about them, use with a third-party vendor to the consumer's benefit. So if I agree that a business can share my information with a third-party vendor to provide more finely tuned services specifically pertaining to my interests based on the websites that I browse or the clicks that I make on the internet, someone who declines to allow a company to share that information with third-party vendors is hopefully going to have a limited expectation of the level of service that the business can provide to them as a counterpoint. We'll see how this actually plays out in reality, but I expect that to be the primary area where we see this issue coming up.
And I believe it's going to be a disaster, because this makes no sense when you compare it to some of the other provisions in the Act. But we'll find out in a couple of months. Let's talk about coverage, because again, this becomes really important for those of you not in California. There's three significant coverage definitions. One is that of a consumer, one is that of a business or a covered business, and then what constitutes personal information. A consumer under this law is not really a consumer. It's a resident of California. And on, we're all used on the consumer side of talking about consumer purpose for household purposes, for personal investment purposes, and so forth. Forget about that. They use the term consumer, but it's much broader than that. In addition, it's got somewhat of an expansive definition. It includes members of your household when you're talking about utility bills. So that if I'm a member of a household and I've got teenage kids or adult children living with me, the household bills and utility bills theoretically can cover the entire spectrum. But what is also making people crazy, and if you want to go back to your HR departments and make them crazy, it probably covers HR matters as well. And I've had a couple of people, HR departments, go apoplectic when they say, "What do you mean we've got to give our information?" Well, you're going to have to give your information. Guess what else you may have to give? Shareholder information. If you've got shareholders in California and you are keeping track of those shareholders, you may get a request saying, "I own a piece of IBM. What do you know about me? How are you marketing to me? What kind of information you've got on me?" And so again, there are a lot of categories here that people are beginning to crop up, where we're finding out, wow, this is very, very broad coverage, because it's not really consumer coverage, it's residential coverage, and we'll get to how that interacts in terms of interstate business and doing business in California. Business itself is broadly defined. It can start out with a sole proprietorship, but generally it's going to be a corporate entity of any type that collects a consumer's personal information and does business in the state of California. And I know your initial thought is, okay, we'll just form subsidiaries and do that work in California and segue, get off. Well, that doesn't work, because an affiliate, if you own a subsidiary, 50% of which is owned by your company, that is aggregated with your numbers as well. So it gets around the affiliate issue of trying to be able to micromanage who's going to be covered by the Act. Now, if you're a business, you're doing business in California, there's three thresholds which we've got to look at. The first one, which is probably the most important one, is that the business has annual gross revenues in excess of $25 million. The second is that you, or in combination with other folks, maybe you share a website with folks, you accumulate personal information of 50,000 or more consumer household services or devices. Devices is a pretty interesting inclusion. Or 50% or more of your annual revenues come from selling consumers' personal information. Now, again, I know that you're asking the question. There are three categories here. What about, is this global? Is this U.S.? How do you measure these terms? Because they're not in the statute. And I would say that the general consensus as to the first one, which is the gross revenues in excess of 25 million is that it's global in nature, certainly US in nature. And so it's going to be pretty easy for even mid-sized companies to be able to pass or maybe fail this this criterion for purposes of whether or not you're covered. What about the other two categories, Sam?
Right, so the second one, dealing with the accumulation, the use of 50,000 consumers' personal information, there the key word is consumers, right? And we talked about consumers is actually a defined term that means a California resident. So in some sense, that is a local California term. The third one is the one that gets really finicky here. On the one hand, we have a discussion about revenues, which when you're talking about the first potential threshold of $25 million in revenue, it's considered to be a global figure. So you have that revenue figure in the third term as well. It's also counteracted, though, by the fact that we have the term consumer in there, right? And so that's a local term. There's a lot of patent ambiguity here about, are we talking about 50% of global revenue for a company comes from handling California residents' information? My suspicion is that that's a lot more narrow than the legislature meant it to be. The CCPA is likely to be construed as broadly as possible. So we're going to want to keep our eye on this third provision for considering really how is that one going to play out.
But if you've got $25 million of revenue, you're probably going to be in on this, and you're going to have to proceed and see how the Attorney General ends up defining these terms. Personal information, and this is a very, very broadly defined term, information that identifies, relates to, describes, is capable of being associated with, or could be reasonably linked to directly or indirectly a particular consumer or household. Now, the cleanup bill, which is SB 121, clarified that a web browser activity is personal if reasonably can be linked to the consumer or household. And you've got an example of how that might be able to be a workaround in terms of your web browser activity, in terms of surfing the internet.
Yeah, so a classic example of household information that might not pertain to a specific user would be information that can be associated with a particular IP address. So if you have a cookie or a tracker on your website that's monitoring clicks and time spent on a given page, it's associated with an IP address rather than a specific consumer, but that IP address can be linked to a household, and there you have it, you're within the CCPA's definition of a consumer. However, there are some cookies or trackers out there, Google Tag Manager, Google Analytics, offer the opportunity to anonymize the data that those trackers collect, such that you would remove the IP address from the data set and therefore try and get outside the bounds of the definition of a consumer's personal information for purposes of the CCPA.
At least as to that category, but that still doesn't mean that you're not collecting information about the consumer. And so it's one example how you might be able to do some workarounds, but not all. This is a non-inclusive list of what constitutes personal information. And actually, the list in the statute goes on for what would be several pages of really enjoyable reading on a PowerPoint presentation. But you really should take a look at this, because at the end of the day, you say, oh my God, all I really need to do is have Joe's name, Joe's social security number, maybe his internet address, and all of these things count, and all of these things can be grabbed, and all of these things can be acquired. And you can see down here, Joe's real name or his alias, as Batman, an account name, social security number, driver's license, things which you normally get in order to be able to identify who Joe is. Commercial information, talked about shareholder information, internet or electronic network activity, so gathering information of what it is you're looking at as long as it can be relate back to you. Geolocation, professional employment information, and a couple of other categories in California law that unfortunately we may have to learn a little bit about. But again, there are many, many other categories in terms of what constitutes a unique identifier that links me to the information that you're grabbing. Now, you're saying, well, wait a minute, aren't there some exceptions? Well, there are some exceptions, but they are really partial exemptions for the most part, because in so many of these cases, you may not have the obligation of deleting the information, but you may have the obligation in any event to tell a resident who calls you and submits a proper request for information as to whether or not you've got the information and that you are collecting it. So, I mean, logically, information you collect because Joe calls up and says, I need you to do a transaction for me. Well, that certainly makes sense. Can you hold on to that information if you want to keep it for your records because you may have some warranty issue where you need to keep it for a while because Joe just bought a widget from me and I need to know how long I need to keep it. Joe may have an account information with me. What about that? You're complying with Joe's instructions as to how to use the data in order to be able to effect a transaction or a series of activities or goods and services. Again, you can keep it, but at some point, what if Joe calls you back and says, I now want you to delete it? Maybe in the case of consumer law, you may have record retention requirements where you have to keep it for a period of time, but we're gonna have to figure that all out. There may be legal obligations such as in truth in lending or ECLA where you have to keep these things. You had some comments here about this issue?
Yeah, I mean, I think there's a real question about how much can you do to manage a consumer's expectations here. If you see the last bullet point, you can treat data in a certain way depending on the reasonable expectations that you and the consumer have or the understanding about the relationship that the two of you are carrying on and the reasons for which they're providing the data. So what's the extent to which you can include additional information in an agreement, in a policy or a waiver, some sort of disclosure that's going to give you some extra wiggle room for purposes of keeping the information on hand so that you can verify that a certain product is subject to a warranty and that Joe is the person who actually bought the product.
And I think that what we've highlighted here is, can waivers work? What happens if you put in a waiver saying, if you want to use our service, you've got to agree that we can retain this information, we don't have to give you the information, we don't have to disclose it, we don't have to delete it. Is that going to work? Unclear, completely unclear, and I think there's going to be some policy interpretations going to be necessary by the Attorney General in order to get through this issue as to what works and what does not. I mean, for example, I mentioned the issue of what about in the case of someone committing a crime? Do you in that case do you develop language initially until it gets clarified down the line by the Attorney General, information which indicates that yes, you are voluntarily agreeing that we can keep this type of information for a period of time. I suspect we're probably going to be putting that into a lot of our contracts in order to be able to protect ourselves from some person raising a claim because of the fact that you violated their instructions. Let's talk a little bit about liability. And there's two sets of liabilities. One is liability by the Attorney General at $7,500 for an intentional violation and $2,500 for unintentional violation. That probably refers to an entire data breach. So in the case of Marriott with their $500 million screw-up, $7,500, who do I make the check out to? Have a nice day. I don't really care so much about that. Marriott probably is in the same category. On the private party side, this is where it really gets dicey because it's actual damages plus statutory damages, as I mentioned a while ago, starting from $100 per incident, and that will be per person, up to $750 per incident. And as you know, for some of you that have worked in the TCPA area, there's massive amounts of dollars which end up being alleged in class actions, and you end up negotiating a settlement if it's part of a class action or whatever in order to be able to get rid of it. There are special rules dealing with the statutory damages for personal actions, and the sole defense appears to be that you had adequate security measures in place to prevent the breach from occurring. And the other day, we were meeting with former head of cybersecurity for the SEC and asked them the question, what are the standards that we'll develop as to adequate security for data breaches? And his answer was, those things don't exist. The rule is probably that if you have a breach, you probably don't have adequate security. That's very comforting because you can imagine how difficult it will be to be able to withstand, to make a motion to, on summary judgment on some of these cases. And so we're going to have to really probably push the issue of whether or not there's some standards out there. And there are some standards out there. There's some data security organizations that say, here's what you need to do. Whether or not that is going to pass muster, whether or not in terms of bank regulators as to what they look at when they do the FFIEC data security examinations, whether or not that is going to prevail. And there's also in each case a 30-day cure period. And I think, Sam, you've got a comment about the 30-day cure?
Right. I mean, this is one where, for data breach purposes, I mean, how much can you really cure for purposes of a data breach? It's not like you can guarantee that you get the data back from a hacker and that you can trust them, that they haven't retained a separate copy for themselves here. So really, the 30-day cure is going to be most relevant for an attorney general action where they say, you know, hey, your disclosure on your website about what information you're collecting is inadequate. You have 30 days to fix that up. And that's really where you're going to see this provision coming into effect. I'll note for the standards question, and you know, if you've had a data breach where your security measures adequate, the NIST on the national level would be one to keep your eye on for purposes of trying to set up security measures that meet those standards, and that you're going to have a easier time defending yourself in court and saying your security measures were up to snuff if you can satisfy those. There's also discussion about the Federal Trade Commission, which would bring actions under Section 5 right now. It has a very general, non-specific authority, and it's brought some actions that wind up with consent orders to try and set out for a company what are the obligations that it needs to put in place to really have adequate security measures. They've run into some challenges. There's a circuit split about how much the FTC can really do to that effect. And we'll get to a discussion about federal preemption of the CCPA, and involved in that question is one about whether the FTC could be provided rulemaking authority to spell out in greater detail what are adequate cybersecurity measures.
Now, one of the interfaces I think that's going to happen here, and this is what Sam's group does in terms of data breaches all the time, is that there's a data breach. At what point does the clock begin to run by recognizing the fact there's been a data breach? Does that really affect the 30-day cure period? What do you do? Because at least in terms of private parties, again, the horse is out of the barn and is running up the hill saying, please come and sue me. And this is going to be a full employment act for plaintiffs' attorneys when they realize the potential of this. And it becomes very, very important to have in place policies and procedures dealing with data breaches and bringing everybody together and determining what you are going to do, how do you go about announcing it. And there may be a rush to the courthouse immediately upon an announcement with a lawsuit being filed by plaintiffs' attorneys saying, let's go get him. And by the way, please make the check out to me, your consumer protection class action attorney. I mentioned special rule for statutory damages, and the answer is that they kind of boil down what constitutes a breach for statutory damages, but it's a lot of things that you can think of that really are major categories in terms of the breach: person's name, social security number, driver's license number, account numbers, which are stolen on a regular basis, medical information, which is stolen. So there's going to be I think a pretty easy standard to be able to say, you stole a bunch of my information, which gives me the right to statutory damages. We will see how that how that proceeds, and whether or not this ends up being a fighting point in terms of individual breaches that take place as we go forward. Let's talk a little bit about some areas that I think are also going to profoundly affect financial institutions, because of the fact that this is the Bank Council Roundtable. Immediately, while they were negotiating AB 375, in order to get it done before the end of the proper time period for the ballot measure, they started negotiating another bill to clean up the mess that they know they were negotiating under 375. And it does correct a number of drafting errors and clarifications on some coverage issues. One of the things it does, which I think is a good thing, is that it extended from January 1st, 2020 to July 1st, 2020 for the Attorney General to issue interpretations, clarifications, and regulations. And by the way, in that regard, the Attorney General in California knows nothing about the Administrative Procedure Act. How do you issue regulations? How do you go about doing a rulemaking? How do you go about gaining information? Now, Sam here knows an awful lot about the technical side of going on the internet and using all of these sub-applications to be able to scrub information, and you have to know about all of that, and you have to know the technical details, and that is simply beyond the ken of the California Attorney General. So when this thing was originally passed, he screamed bloody murder, saying that is simply not enough time for us to be able to do it, and as part of SB 1121, they extended it to July. May not be enough time, but at least it's a starting point. And there's some issue in terms of the effectiveness of these new regulations vis-a-vis the statutory damage provision.
Right, so the private right of action is still set to take effect January 1 of 2020. So what happens when the Attorney General doesn't issue guidance or regulation until July 1st, but you're being sued on January 1st about that same provision? I mean, the answer is you're gonna have to fight it out in court, and hopefully the case drags on for 6 months until the Attorney General moots the plaintiff's issue. But there's certainly still, despite the attempt to clean this up, some room for consternation about how this is actually gonna play out.
My personal view is that you're going to get sued anyway as of starting January 1st because, hey, we all know what plaintiffs' attorneys do. There are some important partial exemptions under 1121, and it creates partial exemptions, and I say partial exemptions, for quote-unquote financial institutions and healthcare providers. And we're going to put healthcare providers on the side. We're going to talk about financial institutions. There's an exemption, a partial exemption for entities that engage in activities set forth in Section 4K of the Bank Holding Company Act and Title V of Graham Leach Bliley, as well as the California Financial Privacy Act. But bear in mind, and this is one of the things you have to bring back, the CCPA's private statutory damage provision continues to apply. So it's a partial exemption. So you may be able to take the position, and we're going to talk about this in a moment, that maybe some of the inquiries and questions and obligations to respond to your customers may not apply to you, but the statutory provision does apply to you, which means that whether or not you like it, you're still going to end up getting sued if you're covered by the act and claim, well, we're a financial institution, they exempted us. The answer is, in terms of the really important part of it, no, they did not. Now, one of the things which we're not going to be able to resolve today, but I just want to reference for you, and I know there's a lot of bank counsel in the audience here, is that the way that they wrote the exemption for financial institutions doesn't work really well. In fact, it works really poorly. And I'll tell you, I was yelling or having a very polite conversation with the lobbyists in Sacramento for some of the bank trade associations saying, guys, you did it wrong. And right now they're holding their breath till they turn blue saying, don't worry, it works. Well, the answer is it may not necessarily work. So we're going to have to wait and see. And I think we may need another round of legislative amendments in order to be able to clarify it. But I will say one thing, when you look at it from a very technical standpoint, for example, in Section 4K of the Bank Holding Company Act, Section 4K of the Bank Holding Company Act are non-bank activities that can be conducted by a holding company, but it doesn't include banks. And so where do you end up? You end up in kind of a giant chocolate mess that we may have to have maybe the Attorney General respond to. And just remember, there is not an elected Republican in California. There's all Democrats in senior positions in the California government. And the Attorney General, of course, is running for governor in a very liberal state. And if you think he is going to give you a break on this, good luck on that one. I think we're going to have to fight this battle and probably going to need some clarification. In any event, when you look at the applicability of the California Financial Privacy Act, many of the provisions here were based upon that act. And while they don't have the same obligations to comply with inquiries, keeping information and giving it back in terms of what you're gathering with people, it's very, very similar. It's probably 3/4 of what's in the CCPA. And so if it ends up that it's really not applicable and just it's a partial exemption, you're going to have to become familiar to see what is going to be going on here, because you've got the other side of the coin, which we're not going to talk about today, which is UDAP violations about the fact that you're gathering information and you haven't complied with it, and you can be off to the races on that as well. But this is an important thing which clearly we're going to have to clean up over the next year. And now let's turn quickly to the CCPA and its relationship to the GDPR.
Right, so back in May of this year, the European Union's General Data Protection Regulation went into effect. This is sort of the CCPA 1.0. There are some similarities between the two. There are some differences. A lot of companies were issuing new privacy policies that we were all getting bombarded with in about May or June of this year, some in April. A lot of companies either tried to shut off doing any business with the EU so they felt like they didn't have to comply with the GDPR. Others went through a serious ramp-up effort to achieve compliance with the GDPR. In any event, if either of those is your business and it looks like you're going to be complying with the CCPA, you're going to have to go through another round of efforts to achieve that compliance, because there are some serious differences between the two. Notably, the definition of personal information includes households for purposes of the CCPA. The definition of personal information for GDPR was incredibly broad. The CCPA is broad as well. There's also a difference in terms of the disclosures that you're going to have to make in your notices and your policies for the CCPA. Generally is asking for a greater degree of explanation as to what you're collecting, how you're using it, who you're sharing it with. That being said, the GDPR is more restrictive than the CCPA when it comes to the actual collection of information. So in that sense, we can find a silver lining in the CCPA. It's also more restrictive in terms of cross-border data transfers. So the GDPR was very restrictive on how you could send data from one country to another, and the CCPA really doesn't get into that issue. And so it's an area that if you worried about it for the GDPR, you won't have to worry about it to the same degree for the CCPA. That being said, the CCPA is much stricter when it comes to the sharing and sale of personal information. And I think there's a really important caveat to make clear here, which is that sale of information for the purposes of the CCPA is much broader than you might conventionally consider a sale to be, where there's an exchange of money for goods. Under the CCPA, the definition of sale is sharing data with some other party for any material benefit. The idea being there that if you are allowing Google to collect information through a tracker on your website, and then Google gets that information, in addition to you getting that information, you've probably sold that information to Google. The idea there would be that Google is then providing you some extra insight on the visitors to your website, and without any money exchanging hands, you've sold information. So an area where the CCPA is going to take a lot broader scope than you might initially think at first blush.
Implementation, and we'll go through this quickly. I mentioned a couple of times that Technically, this thing becomes effective on January 1st of 2020. The California Attorney General is supposed to be issuing regulations. I would not be surprised if there will be a movement to further extend the period of time. When the Attorney General issues regulations, there will be a 6-month period in which you would be implementing whatever it is he or she ends up issuing. So again, it's going to be something we're going to have to be really careful about looking at, including, by the way, if you see down here, it says that the Attorney General can expand the scope of new identifiers. And that's because we know that our little friends, the nerds, come up with all new things when it comes to computers and when it comes to information and data gathering. And if they come up with something which is technically not enunciated in the statute in terms of what constitutes an identifier that can be linked to you as an individual, they can just simply issue a regulation and say that new widget is now covered, this new technology is now covered, and so it's really going to prevent somebody from doing a workaround, and that was clearly an intention. Individual parties can go to the Attorney General as of the moment now and ask for interpretations, and we are in the process of working with several groups that are organizing for the purposes of trying not only to get questions answered, but also offering to educate the Attorney General and their staff as to what exactly is going on, because, again, they really need some education, all very, very smart folks, et cetera, but this is something which is beyond their ken in terms of the fact that they're, for the most part, litigators doing enforcement actions as opposed to being computer nerds that delve into these things on a regular basis. Sam mentioned a little bit about the extraterritorial enforcement issue. I think it's something you need to think about.
Right, so GDPR applied not only to companies that were in the European Union, but companies that were offering their services to the European Union, including businesses here stateside. The same will hold true for the CCPA. How will the California Attorney General enforce the CCPA against a business that's based in Canada or based in Europe? We can glean some information from this about seeing how that has played out on the flip side with GDPR. Aggregate IQ Data Services is a good case that sets up this example. Aggregate IQ Data Services was allegedly affiliated with Cambridge Analytica's misuse of data, particularly regarding EU citizens' Facebook data. It's a Canadian company, but with the Cambridge Analytica breach and with EU Facebook data, it fell within the purview of GDPR. At least that was the opinion of the United Kingdom's Data Protection Authority, and so brought a cease and desist action against AIQ, saying, you need to pony up for the problems you've been engaging in with this Cambridge Analytica data. AIQ disagreed, said, you don't have jurisdiction over us, we're over here in Canada, how are you going to enforce anything against us? And so the UK's enforcement authority worked with Canada's enforcement authority. The implication being that Canada's enforcement authority would bring its own action under Canada's laws for essentially the same malfeasance. That led AIQ to fess up, start cooperating with the UK's enforcement authority. And I think the obvious implication here is that if the California Attorney General is concerned that someone abroad is in violation of the CCPA, it would not surprise me to see that foreign enforcement authority where that business resides help out the California Attorney General and bring an enforcement action under the local laws of that country, and vice versa. If a UK authority or some other EU authority is concerned about malfeasance by a California company, the California Attorney General wouldn't have any qualms about helping out and bringing that enforcement action under the CCPA. There's one more twist here I'll note about enforcement of a foreign judgment. So let's say that the UK were to get a judgment against AIQ, a Canadian company. Questions about whether that judgment could really be enforced in Canada. It's a UK judgment. Does that hold any weight in Canadian courts' eyes? The same question would hold true with a US court. And the preliminary research on the issue indicates that if it's a damages issue, that would say, my identity was stolen in the UK, but I'm an American citizen and I lost $50,000 as a result of it. All right, the damages judgment comes out to $50,000. That's probably enforceable in the United States. A cease and desist order or a fine that's not related to actual damages likely wouldn't be enforced in the United States. So that's a complication that's going to be playing out for purposes of the CCPA abroad, the GDPR here as well.
Now, this is, now let's get to the point of what do you need to do going forward? And I think this is really a list of to-dos that you need to bring back to your respective organizations to get people starting to think about this. We have been viewing all of this from the viewpoint of doing a project plan at institutions. And there's a couple of things which I think logically follow down that you need to look at. First is you need to map current data collection processes, data repositories, and transfer protocols. For those of you that have had the torture of doing a living will under the banking regimen under the last couple of years, finding out who owns what, it can be really, really difficult. Who owns the data? Who's got access to the data? Where does the data go? Does somebody end up aggregate the data? Does it then go to the marketing people? Oh, heck, they didn't show up at the meeting. What are they doing with it, and how are they using it? Who's doing the analytics on it? It is a very, very useful conversation to start having, because when you begin to decide whether or not that you are covered and what you need to give people in terms of responding to just a simple request of, what are you gathering from me, and tell me what you've gathered in the past. This is an initial step which I think will be formidable for a lot of folks. Next, you're going to have to update privacy policies. And when you read some of the really trite privacy policies that are out there, well, what do we do in privacy? Well, we keep your privacy in order to have a really good user experience. That is not going to work. What is your privacy policy? You're probably going to have to be very, very specific about what it is you're doing, and you're going to have to really end up upgrading the privacy policies. Now, for those of you that are used to Graham Leach Bliley, you're probably really close already, but again, you're going to have to rethink about what does it mean, what does it mean in terms of transferring and selling to folks if you've got that obligation. Then you're going to have to be involved in testing and verification, because this is an ongoing system that is going to end up standing up. For larger institutions, it may not be the same as having an AML program or an AML team, but it could end up being a formidable number of people that you're going to have trained up, and someone's going to have to be receiving the information, someone's going to have to be tracking it down, someone's going to have to be answering it, and we're talking about a whole different level of administrative expense which is going to be created if you're going to be subject to this law. And then finally, you've got the training, you've got the monitoring, you've got the risk management and measuring, the audit functions, which, again, all are going to flow down probably from your initial mapping procedure to determine whether or not if you are covered. Keep in mind that the Attorney General is going to respond to a lot of inquiries as to what do many of these things mean, and to be able to get it done by hopefully the middle of 2020. In addition, you've got the delivery of information to a consumer. And if a consumer writes you, assuming the fact you can figure out how to verify the fact that consumer is really Joe as opposed to somebody else, you got 45 days to deliver something to the consumer with the ability to extend it a little bit if you can't get the information immediately. And I suspect that's going to be one fail-safe, which we end up doing initially, because as you get your policies and procedures and operations in order, you're going to figure out whether or not that works because of the complexity involved. So what else are you going to have to do? Well, I mentioned you're going to have to draft and post revised policies. You're going to have to think about contracts with vendors and third parties. It's unclear if you sell the information to a third party and you sell it to them, whether or not you've got any control over the information that gets sold to the third party, and whether or not you can try to yank that information back from them. I think the answer is not, but you're probably going to have to need to think about indemnification provisions and protections, and when you're dealing with your own vendors, how they use the information, because it's probably going to be on you as opposed to on them. So again, in terms of on the bank side, vendor management becomes very, very important, and we've all seen terrible gobbledygook Privacy Act provisions in a lot of these vendor management contracts. I think this is going to become very, very specific in terms of use of consumer data and how it is they need to comply with it. And then in addition, you know, that stupid Staples button that says, what does it say?
That was easy.
That was easy. There's going to have to be a stupid privacy button that you're going to have to post on your websites if you sell information to a third party, that somebody can just click, and I think it's going to be a big button saying, don't sell my information. And it's going to be promulgated by the Attorney General, and it's going to be uniform in its approach. So you're going to have to go in and then, God forbid, talk to your IT people saying, we've got to revise our entire website. And you know what happens when you say that to them. They'll say, okay, fine, I'll see you in 2026. We may not have the luxury of doing that, but it really does involve a lot of analytics as well as a lot of simple web-based processing in order to get up to speed to put this stuff in place. Also, another component, and that is, for whatever reason, you're dealing with children under the age of 13, you can't collect information from them until after, until their parents agree that you can collect the information. And something pretty quirky, between the age of 13 and 16, a minor can agree to collect the information. Well, I remember when my kids were 13 up in the age of 16, and they would agree to anything, which I think is really just something that's frankly pretty stupid in terms of the way they wrote this, and that I think that you should be able to protect your kids from somebody gathering their information, and maybe someday people will realize that this provision was a mistake. But again, something that's got to be built in. Couple of issues going forward, as we have mentioned but haven't emphasized a whole lot. There really is just patent ambiguity in the CCPA, and whether or not the California Attorney General helps us, who knows. There's real overlap and concern as to whether or not the partial exemptions have applied, particularly for banking institutions. We didn't go into great detail about closely related to banking institutions such as like mortgage lenders, et cetera. That may also not work, and so we're going to have to figure that part out. Doing business in California, under the conflicts of, the restatement of conflicts second, California takes the position that they can go grab onto you if you have even minimal contact with a California resident, and that means having contact over the internet with them, and that probably works. It's certainly been their position consistently in terms of licensing of outside folks engaged in financial services. And whether or not there is a pure form of interstate business that will supersede this, I would not bet the farm on that, because they will probably prevail because they will take action against you. And then the final comment is, we mentioned it's a Freedom of Information Act. There's a lot of information, but what everyone is now saying is, hey, maybe it's time to revisit federal preemption. Sam?
So this is a conversation that comes up pretty much anytime there's a major data breach, and unsurprisingly, it came up again when the CCPA was issued. A lot of companies are interested in a federal standard, and ideally they might be interested in having it preempt the CCPA, such that rather than simply setting the floor for what happens at the federal level and letting states take it to the next level, they're hopeful that the federal law, if it ever came to pass, would preempt any state law. Privacy advocates obviously fear that a federal law would water down what was accomplished with the CCPA. So we're seeing that battle take place right now on Capitol Hill in September and October. The Commerce Committee held hearings. They actually brought in Alistair McTaggart, who was the brainchild for the ballot initiative that led to passing the CCPA. They also brought in one of the data protection authorities from the EU, and it looked like they were substantively digging into the issues. And surprisingly, in the wake of some of those hearings, it looked like the Senate backed off what it had been historically chest pounding as saying, we're presumably going to preempt anything that comes out of California, and they backed down from that, and it's been a much more measured response since then. The FTC has been identified as the likely agency that would be engaged in any enforcement on the federal level. They've been already doing that under the FTC Act, Section 5, which is a very general UDAP violation statute. The idea with the federal law would be that they'd have much more specific enforcement authority, but there's still ongoing debate as to whether they would have any rulemaking authority, which would be highly preferred for any business over having the California Attorney General provide the guidance on how to carry out your cybersecurity practices. Without a federal-backed law, we are going to expect to see a patchwork of states that are going to be copying the CCPA. I think, Joe, you mentioned that it was Washington that's already talked about doing something similar. It wouldn't be unlike what we have right now for data breach notifications, where each state has its own law as to how quickly you have to respond to a data breach and notify consumers. Do you have to notify the Attorney General for the state or some other state agency? What's the definition of personal information that's been stolen under a data breach? It differs in every state. You're going to see the same patchwork of compliance issues coming up under CCPA copycats across the country. So obvious business interest in finding a uniform federal standard for this issue. It's come up a lot before, and we obviously haven't had one pass yet. We'll see if this is the final push that makes it actually happen.
What a lot of our clients are now beginning to realize is they may end up with 3 different categories of personal information they have to deal with. One, if they're large enough, how do you deal with the privacy issues under the GDPR? If you're outside of California, you've got all the the non-California privacy laws, which you can handle, and you got a data breach, et cetera. But then you've got, how do you segment that from California? Because Californians are going to start sending you letters saying, tell me about my information, and can you internally have a system that can segment them? That do you want to, or do you have one size fits all and try to be able to fit it all in? Because it's a monumental task to segment, and as Sam mentioned, with copycats, there will be more copycats coming down the line. And in terms of any preemption, I believe it took, about 3 years to negotiate the GDPR and several years to be able to implement. That is well past the 2020 date. And so we will have a lot of mischief going on in terms of privacy advocates who will be staunchly defending this. And again, I know we've all got college tuition to pay, and so I'll leave you with that thought. It's going to keep us all occupied for the next couple of years. Thank you very much for your time.